All right. Well, thanks everyone for joining me today. Hope you can hear me okay. I'm super excited about this presentation because it's with probate, and I really enjoy the probate process. I know it's difficult for families, but the process to go through probate is super complicating. You have to go through the courts, and hopefully, with this presentation, you'll be able to learn a little bit more about that process and just um, it's almost like a cautionary tale, right? Like, you don't want to go through this probate process as much as possible, but if you're in the situation, then hopefully this presentation can help you. All right, so I'm just going to do a quick introduction. Here is our firm. We only handle estate planning, probate, and trust administration. We have two offices in Cerritos and Mission Viejo. We are women and minority owned, and we can help clients in Spanish and Korean. And this is me. Here I am. Can you believe it? I have 18 years of trust and estates experience. I went to UC San Diego and went to the University of Pacific in Sacramento for law school. And I am local. I live in Cyprus and I grew up in Cerritos also, and I speak Korean. This is my partner, Stephanie Reles, and she also has 14 years of experience handling probate. So we have a combined, 32 years of legal experience here to help clients. And she's down south in Laguna Niguel. That's why we have an office in Mission Viejo to help clients down there. Just a quick disclaimer, of course, like, this is not legal advice. It's not tax advice. It's just a very general informational presentation, right? Don't rely solely on this. Each case is different. And that's why I have to tell you, it's just very like a typical probate, what would happen, right? And it's kind of geared toward LA and Orange County, California. Each state has different laws, and even each county might have different requirements. So I usually work with LA, Orange County, sometimes Riverside, San Bernardino, a couple in San Diego, but mostly this is like SoCal is our focus. And these are like just really main like highlights, things that most probates go through. Not a complete list at no point. And if you do have a specific question or situation, you want to talk with your attorney or financial advisor, tax professional. Okay, so what is probate? Let me just start there. This is a very just basic presentation. So probate is the state's way to settle an estate, right? If there's a question about where does this go and who's the heirs and like what's going to happen to it, right? Only the court can figure this part out. So it's going to be after someone passes away and there is an asset and it's like, where does this go? Like, who's the heirs? And the court will then determine, okay, these are the heirs. And if there's a will, was it a valid will? They're going to have that whole proving process. They're going to inventory what is all in this estate. Like, what are we talking about here, right? Going to do that. And if there's any debts or taxes that need to be paid, settling that, figuring out how are we going to pay that? Is there enough assets to pay? What's the order that it gets paid? Things like that. And then whatever's left, then it goes to the rightful heirs. So that's kind of in a nutshell what the court is doing. And so the question is, will my family have to go through probate? And notice I said, will my family, not me, because I'm not going to be here, right? So you have to think, okay, some people are like, well, I'm not going to plan anything. My family can handle going through court. Well, this is what they're going to have to go through. So you're not going to go through it, right? You're not going to be here. It's for your family and family members who are going to have to go through this. So hopefully we can plan ahead and make it a little bit easier. I have a client going through probate right now, and every day she's like, I go to my husband's grave, and I'm just like, why? Why did you put me through probate? Like, it just didn't take too much to like plan things, But anyway, here we are with the probate process. And so, hey, are you going to have to go through probate through this court process? It depends. So the threshold actually is now $208,000. I put a little asterisk right here because that number just changed in April, and that number does change every 3 years because of inflation. And what it means is that if you have any assets, a house, a bank account, retirement accounts, like whatever asset this is, if altogether they are over 208,850, it didn't have a joint account. There was no beneficiary. It was like only in this person's name and they're not here. It's like, where does this go? Then if it's over this amount together, gross value, it has to go through probate. Why? Because the bank, they will not release this money to just anybody. They're gonna be like, okay, it's a lot of money here. I'm not gonna just release it to like, anyone. I want to see a court order telling me where it's gonna go. So a lot of times what happens is bank accounts, maybe it was just one person's name, they're not here, the bank will hold it, they will freeze that account, and they will not release that until they're going to be looking for what's called letters of administration, which we're going to get to in a little bit. In a house, you really can't put a beneficiary on a house. So that's why, it's in one person's name, this real estate, title and escrow will not sell it or do anything to it you can't sell it to anyone else because who's there to sign the deed, right? So sometimes my clients are, oh my God, this probate seems too crazy. Like, I'm just not going to deal with it. If you do not deal with it, then, and you pass away, like maybe your kids have to deal with it. And then nothing can be done with this property. You cannot be able to pass it down. You can't sell it. You can't do anything until you go through this probate process. And by then, maybe assets got like, inflation, appreciation, they are valued more. Maybe it's a little bit harder. You won't have the necessary information. So sometimes probate's hard, but sometimes you have to go through it. Otherwise, you really can't do anything with that asset. Same for retirement accounts, life insurance. If there's no beneficiary, like where does it go, right? And if you don't claim those things for a long time, it's going to go to the state. I'm not saying that the state, like, it's theirs. It's going to go to the controller's office in an unclaimed property situation. And then that means nobody gets it. So this is why probate is so important. I also want to highlight a business. If you have a business by yourself, right, and you're not there, who has the authority to like sign it over to anyone else? Who has the authority to sell it, to close it down, to pay the payroll? Like, all of these things that are just in the decedent's name. You might have to go through probate for that. So that's also something you want to think about. And typically, if you do have these assets, if you are thinking, oh, I have a will, right? That's not going to be enough. The problem is this asset is in your name. You're not here. Where does it go? If you have a trust, awesome. But if you just have a will only, that does not avoid probate. There's also a new law that just happened in April as well. If you have a primary residence and the gross value is over $750,000, if it's under that, it's a shortened probate, which is the next slide. But if it's over, we're living in LAOC. Most of the time it's probably going to be over 750. If it's in your name only, you got to put that in a trust. Otherwise, if something happens, it goes through probate. So just to clarify, not joint accounts, right? If you have it with two names, one person's not there, usually goes to the other. Not assets with the beneficiary. If there's a beneficiary, it goes straight to that beneficiary, no probate. And then, of course, if you have assets in a trust, it's going to go by whatever the trust says. So then here's another one. What if it's under $208,000? Like maybe you just had this vacant lot out somewhere and it was less than that. You can do a shortened procedure. You still have to go to court because you have to file a petition or maybe an affidavit, but it's going to be less than this big formal process. So there is a way to do it, but still, you have to go through court. Who wants to go through that? If you don't have a will, it'll just go to your next of kin. Like you don't have control of it. It's going to be the California laws that are going to dictate where that goes. And maybe that's not what you want to do. So that's why having a plan and preparing is going to be so important. What is an executor? I just want to clarify a little bit of the wording because sometimes people use these words interchangeably, and that's okay. Like I understand what you're saying, but sometimes for the person who's dealing with that, they might be confused. For example, if you say executor, then I'm listening and hearing that, oh, there's a will. You can only be an executor if there's a will. And this person in the will has the authority to, handle the affairs. They're like the point person. If you don't have a will, you can't be an executor. You're going to be called an administrator. And that's the one who's handling the probate. So when I hear administrator, I'm like, oh, there's probably a probate and there's like no will. And this is a person that's appointed. There's something called a personal representative. This is kind of like the general catch-all term, just to say who's the representative of this estate. It could be an executor, could be called a personal representative. An administrator could also be called one. It's just kind of like a general term. And then if I hear trustee, I'm like, okay, there is no probate, or at least there's a trust. And then the trustee is the one who's going to have the authority to handle the affairs of the trust. And I want to mention that the trustee can only handle things inside the trust. The trustee will not be able to handle things that are not in the trust, which means things that are only that deceased person's name. So just a little clarification there. And what are the duties of the trustee? So let's say there's a will, you have to go through probate. Okay, what am I going to do? In this situation, your generally big picture is that you're going to be handling all of their property. You're pretty much stepping right into their shoes to handle things where they left off. You're going to be handling their property, real estate, bank accounts, like all that, taxes, right? You're keeping all the heirs and the beneficiaries informed, right? What's happening in this probate? What are we filing? Like, what's going on? They want to know. And they have the right to know because it's going to be their money, right? Not the executor's money. It's their interests, their assets that are going to be passed down to them. The executor handles the bills and the taxes, making sure all of that's getting done, all the debts and all the creditors are getting paid, all the estate is being settled. And finally, they make sure that all of those assets are then transferred to the rightful owners. You could be an executor and an heir or beneficiary. You could be on like both sides. But usually the executor, if you put on the executor hat, they're managing it. It's not their money. They have to always do things for the benefit of the heirs and the beneficiaries. They can't do anything that's just going to only benefit them, right? That would be a conflict. If the estate needs to go through probate, the executor must handle the probate proceedings or hire a lawyer to do it. So you can't be just sitting on your butt, right? You need to take action. A probate is a little bit different than a trust administration. You know how with probate you have to go through court, and the courts are so busy, so that the court has a policy. Okay, let's get this finished, right? They set court dates and like make sure you're on the ball. And if you don't do it, they're going to want to report. Okay, why? Why aren't you doing this? They have like a policy to get the probate closed fast. Keep it going. Sometimes with a trust, unless the trust document specifically says, there's really not like that much of a timeline. Really depends, but unless you have some kind of reasonable way that it's not moving, usually the timeline for the trust and the probate are a little bit different. And the person who's going to handle that, if you have an executor, which means it's in the will who's number one, who's number two, who's number three, that's going to go priority. If you don't have a will, then usually the next of kin will be the administrator of the estate, but not always, which I'm going to talk about in a second. This is a quick roadmap of the probate process. So I'm going to go through a little bit and highlight some of these steps, but you can see that it's a lot of steps here, right? And this is just like the main highlights that I'm going to try to explain. And this is the reason why probate takes about 1.5 to 2 years to finish in California. It takes a really long time. I've heard that other states, it's like really, a couple months and you're done, but not in California. They got to make it complicating, but there's a lot of steps here. Most of the time when I file like a petition or do something with the court, I'm just waiting for a hearing date. Sometimes they don't set it until 5-6 months out. Like this petition for probate, this is step 1 right here. When I filed this petition, this is like to get everything started. It'll probably be like 2 months out. And then by the time I get like the letters and all this stuff, it's usually like 4 months out till we get to like this section here. Like this 1, 2, 3, these 3 dots probably take about 4 to 5 months just here, right? So let's start with that first step, that petition for probate. What is it? It's actually the court form to get it started in court. Here I'm going to put down what I think is the value of this probate. If it's over that $208,000 mark, if it's over the $750 for residences, I'm going to write that down. Because at this point, nobody has the authority to manage this estate just yet. And you might think, oh, I'm the spouse. Like, of course I have authority. Or, oh, I'm like the only child. Like, of course I have the authority. Yeah, but you don't have like the legal authority yet to like sign anything, sell anything, like do anything on behalf of this estate. And you need this court petition to get that process started and for the court to say, okay, boom, like, yes, you are the one in charge. So before this probate is actually, this petition for probate is done and heard in the court, nobody has this authority, which is a problem because who is paying the mortgage? Who is paying the bills? Who is paying the property taxes, right? So those are all issues that we might be thinking about. Of course, if you do have like an emergency situation, there is a solution. You could file for an ex parte, which means like court, there's an emergency. Like, I need temporary letters of administration. Like, I temporarily need to be like the one in charge until the court can have that hearing, only in emergency cases. But there's a way to do it. You could also have something called a competing petition. Let's say there's like 3 kids and everybody wants to step up and do it. Well, you might have a competing petition here of like 2 siblings, and they're like, I want to be the one in charge. I want to be the one. And it'll probably have to go through trial or get settled. So this is something that could happen. And if you are out of state, maybe for whatever reason, the court thinks that, oh, this person who is applying, yes, they are the next of kin, but maybe they live out of the state, maybe there's something happening with them, the court might say, we have to have a bond on this person. A bond is kind of like insurance. Like, what if the person who's appointed runs away with the money, right? What if they do something crazy and use all the money? Then how are the beneficiaries going to get their money, their assets? So the court may require a bond to be set up so that if they do run away or do something crazy, the bond company is there to, settle debts, pay the beneficiaries, and so that they're protected. So here we are, we filed the petition, we're waiting for the court to say, who's going to be in charge. And then before we do that, we have to send out these notices because if somebody is in charge, like, how do I know they're doing it correctly? How do I even know about a death, right? So we have to send notice to the heirs and the beneficiaries. They could be different people. You could have a beneficiary who's like a charity or something like that. And you could also have heirs who are directly related to you. Especially in a will, you might have beneficiaries. And also a requirement is to publish in the local newspaper. I know this is such an outdated requirement, but the law doesn't change so quickly. And this is still a requirement that you will have to publish this notice so that if there's any people in the local area that are like creditors, or they don't know about this, or maybe I'm a long lost heir or something like that, they need to know about what's happening. When you finally get these letters of administration, it's kind of like your badge of authority. And here now you can do things. You can get assets, you can get money, you can sell property, you can start doing things because now officially you're going to be in charge of this estate. You also have to give notice to the government agencies, franchise tax board. Of course, if there's any taxes due, they need to get paid, right? And Medi-Cal. So if you did use Medi-Cal and you have to go through probate, Medi-Cal could get reimbursed. So this is a very important step that the court will require you to give notice to those agencies, which is another reason why living trusts are so important, because if you do have a primary residence in a living trust, then they may not be able to get some reimbursement. So if you are using Medi-Cal, you may want to consider a living trust. And if you have heirs who live in a foreign country, it could be required that we have to give notice to the consulate, to the foreign consulate. I know, so many steps. And if you do have heirs who are minors, little kids, they don't know what's happening in probate court. They don't even know what probate is. The court might require something called a guardian ad litem, someone to kind of act on behalf of the minor to make sure their rights are, rightfully presented. You might not be able to have like the parent do it because it's like they're probably going to act in the best interest of themselves, right? So the court might require a guardian for the minors. Once you get the hearing date now, and you're officially the one in charge, now you can start gathering assets. And this is where you're going to investigate things. A lot of the times the banks won't tell you if there's like a beneficiary or if there's like a joint account or any information because they're very like private like that. But once you get the letters of administration, now you can go to them, hey, look, I'm in charge of this estate. Is there a joint account? Then if there was, okay, no probate. Did this account have any beneficiaries? No. Were they in a trust? No probate, right? And then if the answer to these are no, which means like it was just in their name, then you have to proceed with probate. And you also have to get an appraisal of date of death value from the court appointed referee. I can't just be like, oh, I think the value was, $1 million or whatever. They're going to want a neutral third party, appointed by the court to make a valuation of these assets. And at this point, which is kind of in the middle of the probate, you'll be able to sell the real estate now. And I can do a whole nother presentation on just this part, but very simply, you'll be able to sell the real estate if you have full authority. There's something called full and limited authority. But if you generally have full authority, if it's like a simple probate, you'll be able to sell the real estate now. You might have to do what's called a notice of proposed action to send it out to the heirs. because of course the heirs want to know, like, how much are you selling it for? Like, what is this, who are you selling it to? Do they remove their contingencies? Like, what's going on? They want to know. If you just sell it without that, first of all, you need to do that in probate. But if you were to just sell it, it's like a piece of real estate. It's not like you can say just kidding and they get the real estate back. So they want to make sure, okay, do the heirs know about this? Do they consent? And is that going to be okay? Is there any objection to that? You do need to open an escrow in probate. That is something that's required. The realtors can get their commission at the sale at this point, but the beneficiaries and heirs will not get this full amount of money, and it'll stay in probate until, like a year later when the probate is finished. Why? Because they want to make sure that all the debts, taxes, creditors, like all of that is settled before they make that final payout. All right, now we are at this part about creditors. This is so important, and I feel like a lot of people don't talk about this part, but this is actually kind of a benefit for probate because there is a procedure in probate where you have to give notice to creditors about who you think is a creditor, who you think is owed money. You give them this notice. Hey, if you have a claim, file it. And so they have 4 months from the date the letters are issued, or 60 days after you mail them this notice to file their claim. And they need to file a claim in court on this case. They can't just tell you by email, attorney, I'm owed, whatever amount. No, that's not acceptable. You have to file it in court. And if you do not file it within this window, you don't have to pay. I cannot tell you how many credit cards, bank debts, that we have saved for the client because of this notice of creditors. When I get a client and they are going through probate, I'm like, do not pay anything. Ambulance bills, like hospital bills, like anything, do not pay it. We have to send them a notice of creditors and see if they file a claim. And if they don't, you don't have to pay them. So this is such an important and almost benefit of probate. Sometimes people go to probate just for this process because they want to kind of get rid of the creditors or see like, okay, what is it that I have to be paid? And also there's a 1-year statute of limitations from date of death for creditors. It's a typical statute for most debts, but really it depends on what type of debt it is. Okay, so it's typically like 1 year. Okay, so here we are. We're almost at the last step. We gave notice to the creditors. We're here about to file an accounting and distribution. We have to get date of death values in this accounting because we're trying to let the courts know and the heirs know what happened here. So what is the date of death value? Did I get anything? Did I receive anything, right? Did I find like additional assets? Was there like income or interest generated? And then was there any expenses that I had to pay, any distributions? Want to be careful because the executor administrator, they cannot get paid anything, right? They might be able to get reimbursement for like funeral expenses and such, but really they cannot be taking any money out. You have to be so careful about this part. But you can use estate funds to pay for like the gardener. Maybe you have to pay for property taxes, like things like that. You will be able to use the estate account. And at the end, we have to provide what is there at the ending balance? What's the final and current values? How much is there left that actually can get dispersed now? Sometimes if you have a pretty easy probate and maybe it's just like family members that are the heirs, everybody kind of gets along, you can waive an accounting. You just have to have that in writing and they have to sign off on it. The good thing is that it just makes the process a little bit easier because you don't have to like down to the penny figure things out and get bank statements and such. But it's also, they'll never know about like exactly what happened. So I think it really depends on your family dynamic and is it easy to do? Can I just do an accounting really quick? I mean, what's the vibe like almost, and see if they'll sign off on it. It doesn't happen too often, but for close-knit families, like sometimes it can. And like I say, the courts needs to approve the waiver and they also need to approve the accounting. Because if they see something that's, oh, this is unusual. Recently, I had a court say, well, okay, why did you charge this much for your attorney fees like this? They wanted an explanation. Or, somebody will be reviewing this with court and the court will ask questions and you have to do like a supplement maybe to explain whatever expense that was. So anything that you file, the court does review it and needs to approve it before it's finalized. If the probate takes longer, you might have to do periodic accountings. Generally, the probates take like 1.5, maybe 2 years to finish. If it does take longer than like a year or so, the court will want like a status report. If it takes longer than that, like maybe you're fighting or like you're having trouble with some assets or something, they might ask you to do periodic accountings about that. And we are also at the final petition part. This is like the last thing that the court wants to see. Okay, kind of like, what's the final report? Like, what did you do? Here, we're going to put everything that happened. We gave notice, we filed our taxes, we paid these creditors, we sold this house. Like, we're doing like a final report because the court wants to make sure, okay, everything's settled, right? There's like nothing else. And, given notices properly given, debts paid, taxes paid, and they'll also review these proposed distributions. Okay, does it make sense that like this is going to happen this way? Do we have enough money? I also want to tell you that at this point is when attorneys and the executors also get paid too. So we're going to have to like, show what's going to happen. Let's say you close out the probate today, but you know that there's things going to be happening for next year. Maybe you have to still file taxes. Maybe you know that the property taxes are due. You can set aside a reserve in anticipation of that. For, just like if it's like something tiny, you can just tell the court, well, look, we're still waiting for the taxes. We anticipate X, Y, and Z. We're going to hold back a reserve a little bit. I also want to tell you there's something called an omnibus clause where if you do find something later and, it was like a piece of property, you forgot to include this in this probate. If, hopefully you did the probate correctly in the order, there should be something called an omnibus clause where it says, okay, any after found properties will be distributed X way, half and half to the beneficiaries or whatever it is. So make sure that's in there. So here, where are we? We filed our final accounting and we have to give notice and, oh, maybe this is it. We filed our accounting, we give notice of the final petition. Okay, here's the accounting. Anybody have an objection to that? If they do, right, they're gonna have to file something, tell the court. Usually if there's an objection, the court will put it on trial. You'll have to, then, it's kind of like any other lawsuit, right? You have to go through discovery, you might have to do a settlement, mediation, right? But eventually, hopefully at this part, people will come to an agreement. Then the court will say, okay, this is final, and then boom. And then at that point, the distribution happens and you are done with probate. So that is kind of like the roadmap here. Does the executor have to accept to their role? Sophia, this is like too crazy. I feel like this is so much. I'm named as the executor. Do I have to accept my role? Like, I really don't want to do this. Seems really complicated. No, you don't have to accept it. You can decline, right? No one's forcing you to do anything. If you do decline, then, if you had a will, hopefully there's like a number 2 person, that alternate executor will now step over. And if not, let's just say we went down, number 1 didn't want to do it. Number 2 died. Number 3, there was no number 3. Who's going to do this, right? Typically, the beneficiaries might step up and say, okay, well, I guess I'll do it. But if there's like nobody, then at that point, the court will step in. I had a client who, like, both of her parents were only children. Like, she was an only child. She never got married. Like, there was no one else. And she passed away. So at that point, there was something called a public administrator who will take over to do that role. But you know what? It doesn't even have to be someone related. I had a case where I was a creditor. And I was like, no one's handling this estate. Let me just, my client, let us just handle it so that we can get paid. So you don't even have to be related sometimes. Of course, there's like an order of priority, but the last resort would be a court-appointed public administrator to do it. Okay, as an executor, do I have to hire an attorney? This seems really complicating. It's not required by law, but in most cases you should. And of course, doing a good job requires knowing the law and like attention to detail. When I go to court, there's a lot of propers, which means people who handle this probate by yourself. And I don't know if you've heard of this anecdote, but like going to the dentist, right? Like you could pull out your tooth yourself, but like, do you want to, right? So you want to think about that. And you can do it yourself. There's probably a lot of help out there. Sometimes the judges are a little bit lenient on people who are doing it themselves. But if you miss one step, right, the consequences. And the court will usually just continue it out. And then it's like taking so long to do. You're stressed out, you're having to learn this whole thing. So sometimes it's easier to just have a professional do it. Since a probate is court supervised, there's very particular forms that you have to use. You can't just like make up your own forms, right? And each, like I told you, each location, each county might have their own special forms too that only they use, like local forms. There are time deadlines too. You have to send out these notices, you have to do these reports that obviously if you're not an attorney or someone who like regularly does this, like how would you know this, right? And if you miss a deadline, if the document is not filed, like there really could be some serious consequences. So you really want to think about that. All that to say, if this probate does have like real estate, if you think there's going to be like some tax liability, creditors, maybe a fight between the heirs, at this point you probably should talk with an attorney to help them guide you through this process properly. And well, then how much does an attorney cost? You know, people, when they think about that, they're like, oh, I don't know if I have the money to pay this, right? And sometimes they're like, okay, well, is it like 4%, 5%, 10%? It's not a flat percentage rate. And there's two types of attorney fees. One is called statutory, which means by statute. It's by the law. Like I don't make this up, right? This is the formula. And it's like 4% of the first, 100,000, 3% of blah, blah, and it just keeps going from there. So so those are kind of like statutory fees on just a very basic ordinary probate. But what if you have extraordinary circumstances, right? Then the attorneys can bill on an hourly rate. Selling real estate is something that the court categorizes as being extraordinary, not in the ordinary course of probate. I had a client where they passed away and like they didn't have any heirs. We had to hire an heir search to find like 32 heirs located all across America. And that was kind of extraordinary. We had an issue with somebody in a foreign country, like somebody was incarcerated, like, tax issues, all of these things that could pop up in kind of a weird situation type circumstance. Disputes with beneficiaries would be one. Maybe you have trouble collecting an asset, and typically attorneys will charge anywhere from $3 to $4.50 an hour. But you do have to meet the statutory requirement before you could bill extraordinary fees on top of that. For example, like maybe it was really easy, this probate part, it's just that this weird circumstance took so long. Well, maybe the court will say, no, you have to put in your hours for the statutory fees first before you can get extraordinary fees. So we do have to keep track, even though it's a percentage. Does the executor get paid? You might be thinking, Sophia, this is like a lot of work. It's going to take like 2 years of my life. Can I get compensated? Yes. A lot of times people serve as executor to honor their deceased person's request. It's my honor. It's like, their estate. I really want to do this for my family. But you are entitled to payment. So whether you accept it or not, that's up to you, but you are entitled to it because nobody wants to be working for free. And I'm sure that they don't want you to be working for free as well. And the exact amount is regulated by state law. And guess what? You get the same amount as attorneys. So most close relatives, friends choose not to charge for state services. And you do have to remember, if you do get that income source, that fees, it's considered income. So you do have to report that on your taxes. Maybe that's why some people don't want to claim it, but their own circumstances. So let me go back to that. This is the attorney fees amount. So whatever the attorney gets is like what you're going to get as well. So let's say the value of all of this estate, real estate, bank accounts, everything that's going through probate is like $1 million. It's like $23,000, right? So that's something that you can do. Now, when clients, I show them the fee, they're like, oh my God, this seems like so crazy. But if you think about it, it's like 2 years of work that we're doing. So it kind of makes sense that it would be a little bit higher like that. How much does then probate cost? In addition to attorney fees, executor fees, which are the same, maybe some extraordinary costs, the court charges fees. So in Orange County, it's like anytime I file something with the court, it's like $500. I've got to publish in a newspaper. Maybe I have to pay a bond. I've got to pay this probate referee to appraise something. Every time I file something, it's like, $435. I think it went up since then. And all these other little costs, they really do add up. And that's why this is just kind of a typical scenario. Let's say on a $500,000 estate. I mean, if you have real estate, really, it's probably not going to be this, but let's just say, then we're at 13,000 in executor fees. If you have a $1 million estate, we're at 23,000. So sample, look, the attorney gets their fees, the executor get their fees, maybe you got some other fees. We've got the cost of administration, maybe 3,000. It's starting to add up. It could be like about $50,000 when all is said and done. And especially if you have only one real estate, one equity, no cash, how are we paying this, right? Especially if you don't want to sell that property. That means your family members might have to come up with this somehow. Or else, how can they go through probate, right? So that's why having a trust would be important. You want to stay out of court. And that's my next slide. How can I avoid probate? This seems so costly. It seems really time intensive. Like I say, it could take a year or more. And I forgot to mention that this is public information. So this means that anytime I file something with the court, you're going to get a lot of solicitations. Everyone's going to know the addresses. They're going to know like how much is in there. All that information is public, and who wants that, right? With a trust, it is private. Nobody needs to know that. And that's why there are a few ways to avoid probate, which is establishing a trust. Of course, we want to do that, right? A living trust, it's very, yes, there's a cost in the beginning to set it up, right? But it stays out of court, right? It makes it easier, it's clear. People can, and one of the things is it'll say, okay, who's the trustee? Who's in charge? Remember in probate, before the court actually says it, nobody's in charge, like who's handling what, like nobody knows. With a trust, you have to write down who's going to be the trustee. So it's very clear with your intentions and what they might be. Hopefully you have a good attorney who maybe talked with the person making the trust beforehand to kind of work out the scenarios and get all the assets into the trust to avoid probate. You want to make sure there's beneficiaries on your accounts. No minors on accounts. Sometimes people put maybe children under 18 as beneficiaries on like a retirement account, a life insurance. You can't do that. What if something happens to you? How's a 2-year-old going to like manage anything, right? So you also want a living trust so that the trust could be a beneficiary on certain of these accounts. And maybe if you have joint accounts too, for example, you have a bank account with 2 people, one person's not there, it goes to the other. But be careful on these joint accounts because sometimes parents will put one child on it. Maybe they have 3 kids, but they'll just put the one that they're close to. If something happens to you, remember, it goes to the other person on the joint account, which means that the other siblings might not get it. It just becomes that child's property, whether they choose to share it or not. I mean, it's technically theirs. I want to say one more thing about this part about establishing a trust, because even if you have a trust, you still might have to go through probate. What? Because when you have a trust, you have to put things in the name of the trust. I have a client who he had this trust. He had it like 20 years ago. He made up a trust. He did everything right. But then he, like 20 or something years later, rolled by and I guess he forgot he had a trust. I don't know. Where he bought another piece of real estate and he just put it in his name. He forgot to like connect it to the trust. And so then obviously it's just in his name. He's not there. There was no evidence that he wanted to connect it to the trust. So we had to go through the trust for certain assets and probate for other assets. So always be careful about funding the trust. I actually did a webinar maybe 2 months back about what to put in the trust, because some things you don't want to put, like maybe depending on what it is, but there is a webinar about that too. And we are already at the end. Oh my gosh. Thank you for attending. If you did miss a webinar, I do have a YouTube channel where everything's recorded. This webinar is also recorded. They gave me a really long name here, but I think if you Google just like Sakamoto and Relis, it's going to be there. I want to help you with your probates. If you're going through this probate process right now, I'm here to help you. Unfortunately, I can't do like, sometimes people ask me, well, I'm part of this probate. Can you just like kind of, piece by piece, like advise me? I really can't do that. I really have to be your attorney or like not, right? But if you do know someone who's going through probate, I do free consultations for that, at least just initially to kind of see. If you are having a probate with another attorney right now, certain circumstances, I'll be able to take that over for you. So I hear a lot where like my attorney's not doing anything. I don't know what's happening in the case. So let's have a consultation about that. And especially if you are like, I don't want to go through probate, I really need to set up a living trust. And of course, we would love to help you with that as well. And I think that's it. And if you do have any questions about that, you can email me separately. Otherwise, stay tuned for my next webinar. It's going to be in about 2 months. Like I try to do one every other month. I think the next one is going to be geared toward children with families and kind of looking toward like college savings and thinking about kind of like the early stages. If you have a minor, how to set up things. The webinar after that is going to be like rental properties. I think and so, we just have a lot of different topics. You're probably getting a lot of my newsletters. And if you don't, let me know. I'll put you on to my newsletter so you can get information for the next webinar. But otherwise, thanks so much. And hope you have a good evening. Bye.